If anyone's trickling in, we're just giving everyone a few seconds to join us, and then we'll get started with today's webinar. Hey, welcome again, everyone. My name is Sifam Tango. I'm the Senior Project Manager of the NDIS Independent Expert Review Advice Service, which is coordinated by National Legal Aid. I'm pleased to host this webinar today. Before we begin, I would like to acknowledge, on behalf of the Independent Expert Review Advice Service and Disability Advocacy New South Wales, we'd like to acknowledge the traditional owners of the lands where we're hosting this webinar. I'm coming to you from the land of the Gadigal and Bidjigal people. We'd also like to acknowledge the traditional owners of the lands where you're coming from today. We pay our respects to elders past, present, and emerging, and extend that respect to Aboriginal and Torres Strait Islander people participating in today's webinar. So today's webinar will be a PowerPoint presentation by Disability Advocacy New South Wales and the Independent Expert Review Advice Service on the Independent Expert Review process. I'll introduce our panel to you shortly. Their presentation will be followed by questions and answers. Before we kick off, just a bit of housekeeping. Thank you to Your Story Disability Legal Support for hosting this webinar. This webinar is being recorded as well as live streamed to the Your Story Disability Legal Support Facebook page. Auslan and captions are available. To turn on the captions, please go to the toolbar at the bottom of your screen and click on the button labeled CC Live Transcript. Then select Show Captions. Please post in the chat if you're having any tech issues. To ask questions on Zoom, please use the Q&A function to ask any questions, so not the chat. You can ask a question anonymously if you wish to. On Facebook, please post your questions in comments. If we don't get to your question, we will respond via email or Facebook, depending on how you're joining us today. A copy of the slides of today's presentation will be sent to people who registered via Eventbrite, along with the webinar recording. If you're joining us on Facebook, please email ieraadvice@legalaid.queensland.qld.gov.au to request the slides. Okay, so our presenters today are Sam Dalal and Nakul Bhagwat. Sam Dalal is a specialist disability advocate at Disability Advocacy New South Wales, where he has worked since 2019. Sam assists people with disabilities and their families with a wide range of advocacy issues, with a particular focus on supporting participants navigating NDIS appeals. This includes providing non-legal information and practical support to people invited to take part in the Independent Expert Review program. Sam is also a member of the Independent Expert Review Oversight Committee. Nakul Bhagwat is a lawyer with the Independent Expert Review Advice Service, where he leads a team of solicitors that advise NDIS participants who have received a recommendation through the IER process. Nakul has experience advising and representing people with disability with cases before the Administrative Appeals Tribunal and the Federal Court of Australia. He's based in Sydney at Legal Aid New South Wales. Thank you, Sam and Nakul, for delivering this webinar for us today.
All right, thank you, Sifa, and good afternoon, everyone. All right, I guess first today, I'm just going to do a brief overview of what today's presentation will cover. So firstly, we're going to be looking at what the Independent Expert Review program is, and then we'll be going in a bit more detail through each stage of the process and what you can expect if you choose to participate in the program. We'll also cover how you can ask to participate in the Independent Expert Review program, and then spend some time going into the non-legal support you can access from advocacy services and the legal support that you can access through the Independent Expert Review Advice Service, and of course how you can access this support. Then at the end of the today's session, as Sifa mentioned, we'll have a a chance for any questions and answers to our panel. All right, so firstly, what is the Independent Expert Review? The Independent Expert Review Program is a new and informal dispute resolution process for people who are appealing a matter at the Administrative Appeals Tribunal, but have not yet had a final hearing in their matter. I'm sure many people here have experience and knowledge of the AAT, but for those that don't, the AAT is the body that conducts external merits reviews of government decisions, such as decisions made by the National Disability Insurance Agency. Participation in the Independent Expert Review Program is free and voluntary, and that means that if you don't wish to participate in your matter, you can choose to continue at the AAT. You can also withdraw from the Independent Expert Review Program at any time without that impacting on your AAT appeal. The aim of the Independent Expert Review Program, firstly, is to try and reduce the number of NDIS appeals which need to proceed to a final hearing, and also to reduce the length of time it takes to resolve these matters. If you agree to participate in an independent expert review, what that means is an independent expert will take a look at your matter and make a recommendation to you and the NDIA about what they think should be done to resolve your matter. This entire process is both informal and confidential, and it occurs outside of your AAT proceedings. The recommendation made by the expert is also non-binding, which means that you can choose whether or not to accept the recommendation or not. If you and the NDIA do choose to accept the recommendation though, the matter can then be resolved without needing to go to a final hearing. All right, so who are the experts? So as of March 2023, there are 16 independent experts that have been appointed. And you can find out the names of this panel of independent experts by following the link attached on the NDIA's website. We won't go into too much about the experts, but I guess to become an independent expert, the experts on this panel come from a range of backgrounds and experiences, but all of them have current involvement in the disability sector, whether that's personal involvement as a provider, academic, or an advocacy background, and at least 3 years of relevant professional experience, such as a tribunal member, judicial member, lawyer, advocate, or allied health worker. And it's important to note that the independent experts are not decision makers like the NDIA and AAT. They're just making recommendations, and they make these recommendations independent of both the NDIA and the tribunal, but they need to follow the same laws. All right, we'll now begin to go through the independent expert review process. And the first stage in participating in the process would be receiving an invitation from the NDIA to participate. So this is typically in cases where the NDIA has identified that your matter might be suitable for participation in the independent expert review, and also in instances where you may have expressed interest and contacted the NDIA, and they agreed that it would be a suitable matter. The NDIA will then prepare an agreement form, which will be sent to the participant to sign. And this form includes consent for the participant, the participant's consent to share information about their matter with the independent expert. Participants can also, at this point in time, seek information from the Independent Expert Review Advice Service information line, or seek support from an advocate before deciding if they wish to participate in this process. The entire length of time of the process is expected to take about 6 to 8 weeks, but may differ depending on the complexity of the matter and a number of other factors. And if your matter is listed for a hearing, it'll try to occur before the hearing date. If you have a hearing very close to occurring, it may not be suitable for the independent expert review, because one of the objectives of the program is to not delay people's hearing dates if one is very close to occurring. You can also withdraw at any stage of the process if you no longer wish to participate in an independent expert review. So the next step is once you've provided consent to participate in the program, the NDIA will then prepare a bundle of material containing all the information and relevant documents that the agency has about your AATF application, including the T documents, as well as any other documents that have been filed by either you or the agency since your matter began. The independent expert will also be given information about the relevant NDIS law and the relevant NDIA operational guidelines. The agency will give you, as the applicant in the matter, a copy of any documents that they give to the independent expert. And you'll also have an opportunity to provide further documents or information to the independent expert if something is missing. Or you can also flag at this stage if you would like to speak directly with the independent expert before they make their recommendation. Consent's important too, and it's important to be aware that even after you have provided consent to share this information, if you change your mind and no longer want the independent expert reviewer to have access to your information, this consent can be withdrawn, but you would no longer be able to participate in the independent expert review program. All right, third stage is the length of time that the independent expert reviewer takes to review the material. Estimated this could take 1 to 2 weeks, but it could potentially take a bit longer depending on the length of the material. And also if you would like to speak with the independent expert reviewer in this time, particularly if it takes a bit of time to arrange that conversation. But basically during this stage of the process, the independent expert will go through all of the material that they've been given, and also speak with you if you want to speak with the if you want to speak with the independent expert about your matter. And they might ask you some questions about the information that you have already provided and the outcome that you're seeking in your matter. This conversation is designed to be as informal as possible, so the NDIA or their lawyers won't be present. And you can also have a support person if you wish, such as a trusted friend, family member, or a disability advocate. Also during this conversation, the expert might identify some additional information that might help them to consider before they make their recommendation. And you can choose whether or not you think it's a good idea to provide this information. You'll be given opportunity in this process, time will be factored in to go and collect that information, but it's important to be aware that that could then add to the overall time it takes for the independent expert review process to be completed and for the independent expert reviewer to review any additional information you provide and come back with their recommendation. I'll now hand over to Nicole to cover the remaining steps of the independent expert review process.
Thanks, Sam. So to pick up from where Sam left off, once the independent expert has reviewed all of the information and all of the documents that has been provided to them as part of your matter, they will prepare a written recommendation explaining how they think the matter should be resolved. It's important to note that the independent expert's recommendation doesn't necessarily have to be the same as what you are requesting or what the agency is requesting. So to give you an example, if you would like 10 hours of support from a support worker per day, but the agency only thinks that 3 hours of support worker time per day is necessary, the expert could reach a recommendation that is neither 3 hours nor 10 hours and come to the view that a different amount of time is what they would recommend. Both the participant and the agent and the NDIA will receive a copy of the independent expert's recommendation, but the recommendation won't be provided to the AAT without your permission. We would suggest, and we'll speak more about this later, but it's generally a good idea to get some advice from the Independent Expert Review Advice Service, for example, or from an advocate that may be assisting you about your options and whether or not you should provide permission for the recommendation to be provided to the AAT. once the expert has provided their recommendation, both you and the NDIA have the chance to accept, partially accept, or reject the recommendation. I'm just going to pause for one moment as I think there's an issue with the captions. I see. Okay, so once the recommendation is has been given, as I said, both you and the agency have a chance to accept, partially accept, or reject the recommendations. The NDIA will provide their response within 10 business days. And what the NDIA has committed to doing is to accepting the independent expert's recommendation in most situations, unless they think there is a legal or a factual error in the recommendation, or the recommendation is inconsistent with the NDIA's operational guidelines. And from the latest update we've received, all the recommendations that have been provided by independent experts so far have actually been accepted by the NDIA, which is a really good thing. If the NDIA doesn't accept the independent expert's recommendations, they will provide you with written reasons as to why they have not done so. What can you do once you've received the independent expert's recommendation? The first thing that I should point out is that there is no time limit for you to accept, partially accept, or reject the recommendation. So as a participant, you can take your time, you can obtain whatever advice you would like to before making a decision. You can access legal advice that we'll talk about through the Independent Expert Review Advice Service, and you can also get the assistance of a disability advocate to help you decide how you want to proceed once you have received the recommendation. What's on this slide here is just a little matrix chart of the different outcomes that are possible once an independent expert has made their recommendation. So as you can see, if the participant rejects the independent expert's recommendation, then your matter is not going to be resolved and it's going to continue at the AAT. Similarly, if the NDIA rejects the recommendation, then the matter is going to continue at the AAT and is going to resolve through the AAT's ordinary processes. If both the participant and the agency partially accept the recommendation, then where you have agreement about a certain number of supports, those supports can be included in your plan immediately, and the remaining supports about which you don't agree with the agency will continue at the AAT and be sorted out and be resolved through the AAT's normal processes, such as maybe through a final hearing. And if both the participant and the agency accept the recommendation in its entirety, then the AAT matter will resolve and you will sign what's called terms of agreement with the agency in order to conclude your tribunal matter. And as we will discuss a little bit later, you can get legal advice specifically about those terms of agreement and what they mean before signing them. To go to the next slide then, how do you or a client go about participating in the independent expert review? So if you have already received an invitation from the NDIA to participate in the IER, you can either respond to that letter, accepting or rejecting their invitation, or you can seek further information about the independent expert review program from the Advice Service information line, or you can seek support from an advocacy service if you are at all unsure about participating. And at the end of this presentation, we will put up details of how you can contact the Advice Service information line. If you haven't received an invitation from the NDIA, but you would like to participate in the IER program, you can contact the NDIA to express an interest by emailing that email that's up on the screen now, and which has also just been posted in the chat. It's important when you get in touch with the NDIA to provide details of your AAT matter, including your name and the matter number, which is always going to be the year that you filed your AAT proceedings followed by a / and then 4 digits. The NDIA is currently prioritizing particular types of matters for referral to the independent expert review pathway. So currently the NDIA is prioritizing supports matters rather than matters which are about access to the NDIS. In particular, the NDIA is prioritizing matters that have been at the tribunal for longer than 9 months and matters where there has been a 20% or greater reduction in a participant's plan compared to their previous plan. Those criteria aren't set in stone, and they are constantly being reviewed by the agency, by the NDIA. As I just mentioned, access matters are not currently being referred to the IER program, but it is possible that they might be included in the future. And I just want to reiterate, if there's one key takeaway from this slide, but also most of this presentation, you can seek further information about the IER process from the Advice Service information line or support from an advocacy service at any time. So, what are some factors to consider when you or a client that you're assisting is deciding whether or not to participate in the independent expert review program? The first point to note, as Sam mentioned earlier, is that the independent expert review's recommendation, the independent expert's recommendation is non-binding, which means that you can reject it or only partially accept it if you do not agree with all of the recommendation. And as part of that, the recommendation will not affect the AAT process. The second point to note is that the independent expert review process is entirely confidential, which means it's not shared with the tribunal without your permission to do so. Thirdly, the IER is completely voluntary. So even if, and you can withdraw at any stage. So even if you decide to enter the IER program and participate with the independent expert, if at a later stage you decide that that's not what you want to do, you can withdraw your consent and the process will end at that stage. Fourth point to note is that the independent expert review process is designed to be more informal than many people find the AAT process to be. So, for example, you can speak to the independent expert without the NDIA or their solicitors being present, and you can also have your own support person, whether that's a family member, a carer, or an advocate present when you engage with the independent expert. The fifth dot point is the prospect of resolution. So the entire benefit of the IER process for many people is that it offers the chance to resolve a long-running dispute with the NDIA sooner rather than later. So it might result in you and the NDIA agreeing to fully or at least partially resolve your matter. And as I noted earlier, even if it doesn't do so, so even if your matter is not resolved, your AAT matter will continue unaffected by the IER process. And finally, the last factor that we'd suggest you consider is that you can access support from an advocacy or a legal service to participate in the IER, or even just to make the decision about whether you would like to participate in the IER process. I'll hand back to Sam now to tell you about the advocacy support that's available through the process.
Thanks, Nicole. So acknowledging that a number of people engaged in independent expert review may already have an advocate assisting them already, particularly if their dispute with the NDIA is long-standing. So many people who've received invitations or are considering whether or not to access the independent expert review program might not have an advocate or be aware of the role of disability advocacy. So disability advocacy is a free and independent service. It's funded through the Department of Social Services, and in relation to independent expert reviews, there's a particular program that is funding advocacy to provide support, specifically with people navigating the independent expert review program. And a role of an advocate assisting with this program is that they can provide a self-represented applicant with practical non-legal support to help them progress their matter, and to understand information, what's going on, and to understand your rights and options throughout that process. Some of the things an advocate can support you with during the independent expert review includes providing you with information about the independent expert review process and answering any questions you might have about that process. They can also help you to decide if you wish to participate in the independent expert review, or if you'd rather continue with your appeal at the AAT without participating in the independent expert review. They can also assist you with a referral to legal advice services, such as the Independent Expert Review Advice Service, and also help you to prepare any information that you wish to provide to the independent expert as a part of your review. Basically, the advocacy support is not just through the initial stage, but through the entire stage of the independent expert review. So you may also get a support from an advocate at the stage you receive the recommendation from the independent expert, and to basically review and understand that decision, and to help you to make a decision if you want to accept that recommendation or not. But again, that's also a good stage to consider getting legal advice as well. Lastly, I note that not all advocacy services have funding to assist with independent expert reviews. And I saw a comment in the chat box about providing a list. So I just wanted to reassure that we'll provide a link at the end of this presentation with the details of all the advocacy services that you can contact nationwide in relation to this funding. But if you're also unsure about which advocacy service is your local service, or because every advocacy service has geographical boundaries, you can also call the Independent Expert Review advice line, and they can give you some assistance with connecting you to advice. But I'll allow Nicole to explain in more detail the role of the advice line. Thanks, Nicole.
Thanks, Sam. So as Sam just mentioned, the IER Advice Service is a service operating to provide information and advice to people considering going through the IER process, or that have been through the IER process. The first point I want to just tell you about is our information line, which is your first port of call to get any information about the IER process, or to be put in touch with advocacy or legal advice services. And I will discuss that in a little bit more detail on the next slide. The IER Advice Service also provides free independent legal advice for people with a disability that have received a recommendation through the Independent Expert Review program. So the critical point there is we can have an advice session with you where we go through all the material in your case, but only after you have received a recommendation. We cannot have that advice session prior to you going through the recommendation, the IER process. So once you have received a recommendation, you can approach us for free advice. What can we provide advice about? So we will go through all of the material that was in front of the independent expert, and we will review their recommendation in detail. We have a lot of experience working on NDIS matters before the AAT, so we can provide advice about the merits of the independent expert's recommendation, whether we think it is sound based on the evidence that was before them. We can also provide advice about factors to consider when you're deciding whether or not to accept the independent expert's recommendation. And it's really important to know that we're not here to tell you whether you should or shouldn't accept a recommendation. That's completely your decision, but we can provide guidance about what kinds of things and issues you want to be thinking about as you make that decision. And when we provide that advice, we can draw on our own significant experience of NDIS matters at the AAT and tell you about what the process at the AAT looks like if you were to continue down that path. Once you've made your decision, we can also provide advice and assistance for communicating your decision to the NDIA. So for example, if you only wanted to partially accept the independent expert's recommendation, we could provide assistance in conveying that in an email or in a letter to the NDIA and to the AAT. And we can also provide advice and assistance about signing an agreement with the agency if you want to partially resolve or fully resolve your matter based on the independent expert's recommendation. And I've just put that line down the bottom of the slide just to reiterate that we can only provide this legal advice specific to your matter after you have received the independent expert's recommendation. On the next slide then is how to access all of the support that we've told you about today. So if you want information about the IER process, if you want advocacy support to help you decide, whether to participate in the IER or to participate in the IER, or if you want legal advice after you have received a recommendation, your one-stop shop is the IER Advice Service information line, which you can contact by phone on 1-800-441-800 or by email at ieradvice@legalaid.qld.gov.au. Both of those are up on the slide now, and obviously will be circulated as part of the presentation when it goes out to everyone watching later on. It's also just been posted in the chat if you want to take down those details. As Sam flagged earlier, you can also contact advocacy organizations directly, and you can find a complete list of the advocacy organizations that are providing support with the IER process on the Department of Social Services website. There is a link in the presentation, and that link has also been posted in the chat just now. That brings an end to our presentation. So we're going to spend the rest of the time allocated for Q&A. I can see the first question is directed towards Sam, so I might pass on to Sam.
Thank you, Nicole and Sam, for that very helpful information about the IER process. Sam, one of the questions that our audience would be interested in hearing is, what are some practical tips for participating in the IER?
Yeah, certainly. So I think in addition to what we've discussed about seeking support from advocacy services and legal support where it's needed, I think a few key points for me. One is remembering that it is your matter. I guess that's similar advice to your AAT appeal in general. It's your matter. You've got a right to ask questions if there's anything you don't understand, whether that's from the NDIA or whether that's anything that the internal independent expert reviewer raises with you if you choose to speak with them. You shouldn't feel afraid or worried about asking questions. In fact, that's better to ask questions about anything that you don't understand, so that can be clarified. And then you can always go away and get some additional advice on those questions after that conversation. Another thing that's really important to keep in mind is to be really clear about the outcome that you're seeking, particularly with the independent expert. I acknowledge that for most people at the AAT, their journey, particularly for supports, is something that they may have been raising for many, many years before they even get to the AAT without getting the outcome they're seeking. But it's important, I guess, to keep in mind the independent expert reviewers looking at everything afresh, and it can be really helpful from the outside just to very clearly state exactly what the outcomes are that you're looking for, so they can have a look at that with a fresh set of eyes. And along with that too is, to the extent possible, if you have arranged to have a conversation with the independent expert reviewer, just to have a look over the information and evidence you've got, particularly the key information that you've collected that supports what you're after, just to make sure that the independent expert's aware of that information and anything that you want to say about that information. And that also, even if that idea of communicating with the independent expert feels a bit daunting, just to remember that you can have a support person such as an advocate to assist you with that conversation, but also to assist you to prepare for that conversation as well, so you feel as ready as possible. Was there anything that you wanted to add to that question, Nicole?
Sorry, it was just unmuting myself. I think you've covered the vast majority of what I would say. I guess I would just reiterate that there is advice available, and that advice is independent and free and confidential. And I would urge anyone thinking about going through this process or that is going through this process to reach out and get that advice. And I think, at least in my experience, it can often be a really clarifying or really reassuring thing for a participant to do, to just have someone that can cast fresh eyes over the material in the case, can cast fresh eyes over the recommendation, that brings a lot of experience working in these types of matters, and using that advice not to try and take over the decision-making process, because ultimately, as Sam said, it is your matter, but just to provide a sounding board and provide some guidance and advice to help you make the decision that's in your best interests.
Thanks, Sam and Nicole. And just to that point, Nicole, I suppose another reason would probably be to get the opportunity to ask any questions about things that people are unsure of. So would that also be part of the advice process?
Absolutely. And so it might be, for example, that you're asking a question that even the lawyer doesn't know the answer to, but they can help you find the answer to that. They can help you communicate with whoever you might need to communicate with to get the answer to that question. But most of the time, often they will have experienced this before, because you're not the only client they've advised, and they'll have seen these issues before. They'll understand how best to answer it, or how best to resolve it if there's an issue that needs to be resolved, and you can really benefit from having that experience and that insight.
Yeah, thanks, Sam and Nicole. I think those were some really great tips that you've shared there. So another question we've received from someone in the audience, and I'll ask you, Nicole, to answer this one. Can the independent expert only look at some supports, or do they consider the whole plan?
So the independent expert can look at the whole plan, and they can make recommendations about any supports that they consider should be funded based on the evidence that is before them. But I think, practically speaking, they are likely to look primarily at the supports that they've been directed to look at. So in the referral that goes to the independent expert, there'll be a list of supports that you and the agency have been arguing about, or have been in dispute about up until now. So I guess my recommendation on this front would be, if there is a particular support you want the independent expert to consider, you should let them know, or you should ask the agency to let them know as soon as possible, so that to make sure that they do consider it, because you don't want to take the risk that you think they might consider it, but then they don't, and then the recommendation comes out and it doesn't address the supports that you in fact want. So I think the biggest takeaway is, if you want the independent expert to consider a particular support, you should let them know as soon as possible.
Thanks for that, Nicole. You are going to be in the spot for a little bit, because I've just had a look at a couple of questions that are directed at you, but I'm sure we'll get back to you again, Sam. So the next question for you, Nicole, that has been asked is, usually you're limited to one legal advice appointment during a normal administrative appeals tribunal review. Does this limit apply to our IER Advice Service?
So I'll just start by saying I think that limit of one legal advice during the normal AAT process might be different at different legal aid commissions around the country. So I don't want to speak for other legal aid commissions, but for the IER process, our approach is consistent nationally, and that is that you will be able to get one advice appointment after you have received your recommendation. If there are exceptional circumstances which require a follow-up appointment, or if you decide to accept or partially accept the recommendation and would require and would like some advice about the terms of agreement that you will be signing to resolve the matter, then we can offer a follow-up appointment. But I think the general rule will be that a person will get one advice appointment after they've received their recommendation, and that will generally be what we are able to offer to clients. But I guess I would just encourage, any participants and advocates on this call, where if there are issues that crop up after the delivery of that advice, please do reach out and just ask. We may not always be able to facilitate a follow-up advice, but if there is some sort of circumstance that would justify it, we'll only be able to offer it if you do ask. So I'd encourage you to ask.
That's great to hear. Our next question is around how the project runs, which I'm probably going to jump into, but of course, Nicole and Sam, if you needed to add to anything, I would ask you to. The questioner asked how long it takes for the NDIA to respond to an expression of interest to participate, where there's been prior invitation, where there hasn't been prior invitation to participate that's come from the agency. So the agency hasn't given a precise time frame for when they respond to expressions of interest, but they take into consideration the state of evidence so that they can form a view about whether or not the matter is appropriate to refer to the independent experts. And you could also follow up directly with the agency if you have to, if you've put in an expression of interest and are yet to receive a response. Sam, was there anything from your experience that you would want to add to that?
Yeah, thanks, Sifa. I was just thinking that one through, and I guess this would be in terms of the independent expert review email address we provided in an earlier slide. My understanding is that they're fairly responsive in communicating with people, but I think there might be some delays around actually if you're talking about how long does it take to actually get a response about whether or not they agree to participate. I think that could potentially take some time. There's not a clear time frame that's been given, and I think what that's most relevant to is the demand, I guess, for participation in the process, and that's where Nicole went through the prioritization criteria earlier. So I think all I can really say is if your matter meets one or more of those prioritization criteria, it's more likely that the NDIA would be able to send you an invitation. But if it does not, I still think it's worth putting your matter forward to the NDIA and explaining why it should be considered, especially I'm conscious that some of these matters are time sensitive, especially if they're already timetabled to a hearing. So I think my advice to that would just be very clear with any upcoming tribunal deadlines or hearing dates, if you have them in your matter, when making that request to the NDIA, so they can try and take that into account as well when prioritizing those matters. But I think it's a resources question too, in terms of 16 independent expert reviewers, how many of these matters, I guess there's a decent amount of time that each independent expert reviewer needs to spend with each matter. So making sure, I guess, that process is followed in a way that allows that each of those experts can actually make good quality decisions as well. The last thing I was going to say is those that aren't given an invitation, I believe, are going on to a short list that the agency has communicated that it's regularly reviewing, especially as those prioritization criteria change. So just because you might not have an invitation immediately, you may potentially be invited to in the future. particularly if those prioritization criteria change.
Thanks, Sam. That was really helpful to hear. There's a question here, Nicole, that I will swing back to you for, and that's around the decision-making process. So our question has asked, who's the decision maker at the agency in deciding whether to accept the IER recommendation? Is it the case manager, chief counsel, or a hearing oversight committee, or another delegate?
Thanks, Sifa. And it's a good question. It's not something that we have a 100% certainty on, because obviously, we don't necessarily have perfect visibility on the agency's decision-making processes. But I'm quite confident that the decision maker in these cases would be the case manager that has experience with the matter and has been providing instructions as part of the AAT proceedings up until the IER process. So I don't have any reason to think that it would be anybody else that would be making the decision. And of course, that decision would be based on their experience with the matter and the legal advice they're getting about the recommendation. But I'm reasonably confident that it would be that case manager making this decision just as they would in an ordinary AAT matter.
Thanks, Nicole. Sam, you touched on an earlier answer, you touched on the suitability of matters to recommend to the IER process if someone were to put in their expression of interest. So related to that, there's a question here about some examples, asking for some examples of suitable matters for the IER process. Are you able to add to your earlier views on just what would be considered suitable or unsuitable for the IER?
Yeah, thanks, Sifa. That's also a really good question, and I think something that there's probably a bit that could be said on, but I think just generally speaking, and thinking that remembering that the independent expert reviewers coming into this and having to make a decision in a relatively quick time frame about their recommendation, I guess a suitable matter ideally would be a matter where all the information that needs to be gathered in the matter ideally is gathered. That's not to say that in speaking with the independent expert that they might identify an additional bit of information that needs to be clarified by either party during the independent expert review, but hopefully that's very small or very minor information or clarification that's sought, because that would potentially add a bit of time to the process. So I guess the most suitable matters would be ones where the applicants already gathered all the information that they think they need to support the supports that they're seeking. The NDIAs gathered all of their evidence that they think they'll need. And that information's relatively settled, and the parties are just in a position where they disagree with the outcome. And that's why it's then being referred to the independent expert reviewer for a third party to cast a fresh set of eyes on that evidence. For that reason, I think a lot of the matters that we have seen go through the process are typically matters that have reached the end or are reaching the end of what the tribunal's alternative dispute resolution process is, which is typically the stage where most of that evidence is gathered through some back and forth discussions between the parties. And they're typically matters that are listed for hearing, but that hearing is likely several months ahead into the future. So I guess there's a good bit of time that can be used productively with the independent expert review process to potentially reach a resolution and prevent that matter actually going to a hearing. I hope that helps with that. I guess the only other point to note is that, again, I don't believe access matters are being considered, but if you have an access matter that you think would benefit from that process, I think it's still worth contacting the NDIA. Again, provide them the details about where the matter's at, that the evidence is fairly settled, and that you see the benefit in the process, but I'm just aware that as a general rule that they're not sending out invitations to access matters at this point in time. But you never know, and that could potentially change in the future. So I think it's at least worth contacting them and putting those matters on their radar.
Thanks, Sam. And Nicole, from a legal advice perspective, I mean, the IER Advice Service obviously gives advice at the time once a recommendation has been made. But I suppose from that point, if you can theoretically work backwards, do you have anything to add around what may or may not be a suitable matter?
Yeah, I was just going to add one point, which is, I think, a very lawyer point, which is that there are some cases where all the evidence is in, there's no further evidence to gather, but there is just a legal dispute between the parties. And when I say a legal dispute, there might be some disagreement about the meaning of particular words in the act, or what is the meaning of particular words in the NDIS rules. And especially in cases where the tribunal may not have considered that particular legal question before, it may not be considered suitable for an independent expert to be making a decision because there is uncertainty about what the actual state of the law is. So I would just add that in as another kind of example of a matter that might be considered unsuitable for the independent expert because the agency's view is we don't actually know what this part of the legislation means. So we need to ask the tribunal to make a decision, a binding decision about it.
Thanks. That's a really important point. And I suppose at that point, if you were giving advice to a matter that had gone to the expert review, and that was a concern that you'd identified, that's something you'd be able to give advice about and options going forward?
Absolutely. So, there are, as you might expect, there are areas of NDIS law where we take quite a different view as to what the law means compared to the agency. And so, for example, if an independent expert's recommendation was to be based entirely on the agency's understanding of the law, we could explain what our difference of view compared to the agency's was to a person that comes to us for advice. We could give them an understanding of what the prospects were of the tribunal agreeing with us or disagreeing with us. We wouldn't be able to necessarily reduce that to a, particular number or percentage chance, but we'd be able to give an indication as to what we thought the chances were. And once a participant had all that information and understood that there's one view of the law and that may not be the correct view of the law, they can make a decision in light of all that information rather than maybe not having some of that information about those legal aspects of it.
Thank you. Following on from that, in terms of the advice process, there's a question here again for you, Nicole, because you mentioned earlier that there was no time limit for considering the expert's recommendation. And the questioners noted, presumably a client can't hedge their bets indefinitely to see which outcome will be better, the IER or AAT. What's your response to that?
It's a really good question. So, and I guess, a little correction on my no time limit point. There is a time limit, which is, has the AAT made a final decision in the matter? And once the AAT has made a final decision in the matter, at that point, you can no longer then accept the IER recommendation. Let me explain why that is. So, as we've said throughout this presentation, the independent expert's recommendation is non-binding. You can decide whether to accept it, partially accept it, or reject it. If you do accept it, and the agency also accepts it, what makes the decision binding on both you and the agency is signing an agreement, and that agreement is in the tribunal. So you sign an agreement to bring your tribunal matter to an end. Now, in the same way that can only happen once, you can only bring the tribunal matter to an end once, the tribunal can only make a decision about your matter once. So if you get an independent expert's recommendation, you don't make a decision about it, you go to a final hearing at the tribunal, and the tribunal then makes its decision, you can't then come back and say, oh, actually, we want to sign a settlement agreement with a different decision, because the tribunal has already made its decision and its power is extinguished, which means it doesn't have the power to kind of make a new decision or authorize a new settlement on a different basis. So the question is a very good one, and the questioner has a good point, which is that practically there is no kind of immediate time limit on making your decision about the recommendation, but the hard and fast deadline is a decision of the tribunal. Once that's made, you can no longer go back and accept the recommendation.
That's great. Thank you, Nicole. And just quickly, just related to that point is if a client has an upcoming case conference while they're involved in the IER process, what happens in that scenario?
Sorry, I didn't quite catch that. Do you mind saying that again, Sifa?
Yeah, if a client has an upcoming case conference while they're involved in the IER process, what happens in that scenario?
The tribunal process should go ahead without any interruption, unless the participant themselves requests that the tribunal process be put on hold while the IER process is happening. But the agency does not tell the AAT who is and isn't involved in the IER process. So the two processes can run parallel to one another.
Thank you. We're almost out of time for questions, so I'll probably just ask the last one, which relates to some of the matters that we were talking about just now around the options. And perhaps it's a matter for just clarification, Nicole and Sam, if you had anything to add to this one, which is around whether the independent expert can make a recommendation different to what the parties have requested as the outcome, and or consider the law or supports outside each party's submissions.
I'm happy to speak to that. So yes, the answer is yes, the expert can make a recommendation different to what both sides are putting to the expert. So in the example I gave earlier, where one side is asking for 10 hours of support a day, the other side is saying 2 hours of support are reasonable and necessary per day, the expert can say 0, or they could say 5 in the middle, or they could say 15, but they have the freedom to make their recommendation based on the evidence before them, not on what the parties are saying the recommendation should be. Similarly, in terms of the law and other supports, the expert has the power to reach whatever view they consider to be the correct one. So that includes the law. They can reach a different legal understanding of the law compared to what the agency or the participant is arguing that they should reach. And they could also recommend an entirely different support to the one that the participant is requesting or that the agency is arguing should be provided. As I said earlier, however, even though all of that is theoretically possible, I think in practically speaking, if you want the expert to consider something, whether that's a particular support, a particular outcome, or a particular understanding of the law, then it's always going to be in your best interest, I would think, to put that directly in front of them and to very explicitly say, please take this into account, or please consider this support. Because if you don't, then I think there is a good chance that the expert won't turn their mind to that particular support or that particular understanding of the law.
Thank you. And thank you to everyone who's engaged in this webinar by asking those questions. There are a few that we haven't been able to get to, and if you've registered through Eventbrite, we'll be able to email you, and if you've asked your question on Facebook, we'll also make contact to respond. So thank you again, Sam and Nicole. That's been very informative, and I think reiterates, the importance of this process as an avenue to resolve matters before the tribunal, but also to reach out for that support that's available. Whereas advocacy support for those early stages during the process, and definitely once a recommendation has been received to get legal advice. So I thank you both for attending today. Thank you also to our interpreters, Yasmin and Kali, and our captioner, Denise. A final reminder that free advocacy and legal support is available to people taking part in the IER program. Call the IER Advice Service information line on 1-800-44-1800, or you can email ieraadvice@legalaid.qld.gov.au. We would love to hear from you, so please complete the survey, which will appear on screen when the webinar ends. We'll also share it in the chat and on the Facebook live stream and send it to everyone who's registered via Eventbrite. A recording of this webinar will be available on the Your Story Facebook page. It will also be added to YouTube in the coming weeks. A copy of the slides will be sent to people who've registered via Eventbrite, along with the webinar recording. If you're joining us on Facebook, please email ieraadvice@legalaid.qld.gov.au to request the slides. Thanks for joining us, everyone.